Good morning, everyone. Thank you for joining us. My name is Barry Miller. I'm an attorney and the president of the Closing Agent. Thank you for joining us today. Great response today. Great RSVPs, lots and lots of hundreds of people, literally. So, a lot of you were here last month. We did the FAR-BAR contract, and today we're going to go over the addendums. First, we're going to use the FAR-BAR addendums. Then we're going to get into some special addendums. And then the last 15 minutes, we save all year long actual real life addendums to show you as an example of what is out there. So first general rule is if you have an addendum, you need an addendum, you should look to the FAR-BAR to see if there's a pre-printed one, because why reinvent the wheel? Now, sometimes you can't. So we're going to kind of go through the do's and don'ts today. So to ask questions today, because we love your questions, go to the questions tab here on the GoToWebinar, and you can put your questions. We'll have plenty of time to ask that. So let's kind of delve into what we're doing here. So the addendums, as we said, the standard FAR-BAR addendums, use only the FAR-BAR addendums. Be careful. Do not use the CRISP, because you guys have heard me say a million times, CRISP is crap. The CRISP addendum is no good. I see a lot of times they'll use the HOA addendum with CRISP with the FAR-BAR addendum. This conflicts because in the CRISP addendums, it refers to paragraphs in the CRISP contract. And then if you refer to it, those paragraph numbers, and you're using a FAR-BAR, it will make no sense. So be very careful when you do that, because it can cause lots of angst and lots of problems. So let's kind of get right into it. First is the condominium rider is A, and of course B is the HOA. They're very similar. Now, one thing you need to be very careful of is make sure you have the right information on there. So what I always recommend, if you're a listing agent and you're using condo or HOA, fill it out, post it to the MLS so that the buyer's agent has that all ready to go and just has to plug in the buyer's name. Now, the reason is so that you as the listing agent can put on there how much the HOA dues are, if there's any special assessments coming up. You can include in there, for example, if there's parking spaces or parking garages, and it'll just make everything go smooth. Now, the other thing I've always told everyone to do is when you take a listing, call the association or email them and ask for the information. Now, a lot of times they'll say they don't want to give it out, or they can't. Just say to them, look, I'm not asking for anything confidential or anything on the account. I just want to know, can you confirm the dues are, $250 a month? They may say, no, they've gone up, or they're going to go up. Is there any pending litigation, any special assessments? Does the HOA have to approve the buyer? So things like that you can find out. And it is difficult because let me tell you, I was just doing a contract in a condo for a client the other day, tried calling the manager. She wouldn't respond. I sent her a nice little email. Again, no response. My assistant then called for me, and she went into a tizzy that she can't provide anything and she's not allowed to talk. So we called her supervisor, and then her supervisor said she provided. Interestingly enough, yesterday, I emailed it to her, still no response. So it is a little bit challenging sometimes to get that done. So the other thing to make sure in these condominiums and the HOAs, you always got to ask the question at listing, is there more than one association? So you can have a condo association be inside a master association. That is common. So you just got to be careful and make sure you have that. You got to ask all those questions. So the other thing you got to make sure is to find out, are the dues monthly, quarterly, semi-annual, or annually? Now, most of them are monthly. That is the norm. But again, don't presume. So the other thing is at closing, the seller has to close out their account. And that's why we get an estoppel certificate, and the association will charge for it. So your client will be getting a call saying we need their credit card to put that on there. We have to pay for them in advance. So that's part of the process. Now, the other thing too is we wait to order them for two reasons. One is to make sure the contract's going to go through, and the other thing, it's got to be timely. So let's say you go under contract today, but you're not closing till the end of September. Well, we wouldn't order the estoppel today because there's too much time. They have to be relatively close to closing, and then the seller's September payment won't be reflected. So usually what we'll do on that is order it like September 10th to make sure we have enough time. And some of these associations are right on it and quick. Some of them are very slow. So it's very, very challenging, as you all know. You got to make sure that the non-developer disclosure, you got to have the buyer has to receive a copy of the documents. And that's another thing to ask the association when you talk to them. Can you give me the URL link? That way you can put that in your realtor remarks and also disclose that on the condominium rider of where that's available. So option A is the confirmation that they received the documents, and B is that saying that they want the documents, allows the buyer to void the contract if they don't have it. Now, the big thing on both of these addendums is, and the reason you got to pay very careful attention is, and we had this, I always get the call, Barry, get me out of the contract. So one of the things I first look at is the rider. Then I say, well, let's look at the rider. Is there anything missing or is it incorrect? Well, yeah, they put the dues are 100 and we found out they're 150. Well, you can void the contract then. The buyer can void it. So you want to make sure everything in there is accurate. So I just had someone last week called me that had a situation where the seller did not disclose that there's a $1,500 capital contribution till the day of closing. Of course, the buyer's short on cash and it creates havoc. So you've got to ask these questions up front. Capital contribution. Also ask, how much is the buyer required to pay up front? Sometimes they'll say, oh, we require 2 months up front. Let's make sure everyone knows that to make sure the buyer has enough cash to close. The other thing that's coming up on these estoppel certificates is they'll show if there's any violations. So we recently had one where it showed that there was a violation. It said there was two things on there. One, the garage door needed to be fixed. There was some issue with a dent in it, and that the lawn had too many weeds, dying issue. So the realtor that we were assisting was representing the buyer who called us that said the title company took the position that they're not going to do anything about it. They take it the way it is. It's an as-is contract. So I said, well, first of all, your title company shouldn't be telling you that. They're not attorneys. But in order for that title certificate the estoppel certificate does affect title, because if the title company knows that there are violations, they have to put an exception on title. Now, most buyers are going to say, no, I'm not going to accept it. So here's the logic. Paragraph A says that of title to the contract says that the seller has to deliver good and marketable title, and it can't have there's certain exceptions that can be on there, but this is not one of them. That's not a permissible exception. So therefore, my feeling is, and the prevailing theory is, if there's any violations, they've got to be taken care of. Well, the seller said, this is an as-is contract. I don't need to do anything. Well, the problem is the seller didn't disclose that this was technically a violation of the HOA rules. So they failed to disclose. Now they said, well, we didn't know it was a violation. We weren't cited yet. Well, even though you're not cited, it still is a condition. So it has to be done. So in that case in there, it turned out that the buyer did hold their position. Finally, after the underwriter for that other title company was contacted, they agreed with me and they ended up having to resolve it. So you've got to, as agent, should ask the title company to send you a copy of the estoppel, especially buyer's agent, so you can review it. And if it shows a violation, contact the listing agent and say, hey, here's a copy of this. This needs to be taken care of. So something very, very important. So Again, it's got the boxes on addendum A, the buyer's request for the documents. Yeah, it shows that they received the documents. Common elements, parking, this is often overlooked. So you got to make sure is there's a parking space or a garage that's assigned, we've got to include it. Then we also find out if it's deeded or by assignment. Now, most of them are by assignment. I like them deeded. When I draft condo docs for condominium, I put them deeded because it's easier to track and follow. But most of them by assignment. And then it's by assignment, we need to find out, does the association have their prescribed form? Most of them don't. We do have one. We automatically will include an assignment as part of the service that we do. Most title companies don't. If they don't, you should ask them. If they will not do it, then you might have to have an attorney do it or find other resources for that. But again, realtors cannot draft these. If the client says, will you prepare it for me? You have to tell them, I have a license to sell real estate, not to draft legal documents. Okay, the Homeowners Association Community Disclosure, that this is all governed by Chapter 720. And again, if you don't provide it, you can avoid the contract. I just had one came in Seminole County yesterday, $600,000 deal and no rider for the HOA. And I said, guys, you've got to do this. So they're going to get it done. Now, here's an interesting question that keeps coming up. So let's say you do the contract, and then 3 days later is when they do the either A or B addendum. When is the effective date? Is the effective date when they deliver the contract, or is it when they deliver the addendum? I believe it is when they deliver the addendum. Why? Because since the contract can be voided, it's not complete. And since the intent of the party clearly was to have that addendum, and in fact, they did do the addendum, the effective date would be when the addendum is delivered, because it's an integral part. So the HOA addendum discloses whether the buyer must become a member of the association, whether there's restrictive covenants, the obligation to pay assessments. It'll show in there if they don't pay, can they be liens, the fees on the common facilities. It'll show all the covenants in there by the developer, or if the developer turned it over, by the association. So you've got to have the full documentation, all these. Now, don't forget, this is also part of your title work. So when you get your title commitment, the declaration is part of it and can be viewed there. And it's also on Orange County, the comptroller, and the other county, the clerk's office, that is there for it. So you can always get a hold of those. Okay, seller financing, not a big thing right now because, you know, rates are low, interest rates are good. We don't have that. It does happen once in a while. I just did a contract yesterday where the seller is holding a $35,000 second mortgage. So this is pretty self-explanatory on the seller financing. You've got to just fill out the what type of loan it's going to be, and if it's going to be a balloon mortgage, which most second mortgages are. Like the one I did yesterday was for $35,000. They're going to amortize it, principal and interest, over 20 years, and then have a 5-year balloon. So that's something we can prepare at the time for closing and accommodate everything that's on there. I do always recommend, though, that the seller does get a lender's title policy. The buyer is obligated to pay for that. That way they have got that extra insurance coverage involved in there. Now, if you are going to do seller financing as a first, of course, that's fine. We can do all the terms and have that there. One thing you should do if you're going to use seller financing on a second, just be careful, because check with the lender first, because sometimes they have a restriction that says no secondary financing. So this one I did yesterday had FHA, and I said, before you all go through this and sign it, check with the lender, because many, many times with FHA VA, they do not allow secondary financing. So just always be aware of that. We always want to try to make sure things to look for is a lot of terms that aren't there. Some title companies do notes and mortgages. They're not supposed to. We do them out of the law firm, and we do it that way to be compliant. but you got to be careful because some of these title companies use these forms, they don't have special terms. Like, for example, we'd like to have in the second mortgage that if the borrower defaults on the first, that constitutes a default for the second. You always want to have that in there. That way, if you know they default on the first, you can kind of scurry in there and maybe file your action and take some measures to save that. Now, if it's not going to be the purchase money mortgage and mortgage not to the seller, some things you've got to think about is grace periods for default, right of repayment in whole or part, in other words, a prepayment penalty, acceleration, you have to make sure that's in there, prior liens and encumbrances, not allowing modifications or future advance under the first mortgage. Buyer insurance, you want to make sure you have proof of insurance, and form and content required by the seller. So those are some of the standard things that are in there. Okay, we got joining us now, fresh out of his court hearing, Christian Walters is going to share the stage with me here.
Good morning.
How's your hearing? I heard the phone died in the middle of your hearing.
It did. And
hopefully you weren't in the middle of talking with the judge.
I wasn't. The defendant was, thankfully. So I called into my cell phone real quick. And that was after having to battle traffic this morning to even get here. So.
Oh yeah, I heard the 408 was
it was awful. Can you back up one for me? Back to the seller financing. Just a quick note on this. Ignore my my casted arm here. Don't get on the Lime scooters. You'll hurt yourself. With respect to the seller financing, just know that in every instance, seller financing is not available. The terms of Dodd-Frank substantially limit the ability of people to obtain financing. Seller financing is the exception, not the rule. And you still need to qualify the seller, if they're going to do seller financing, under the 1 property or the 3 property exclusion under Dodd-Frank. And you'll see that on the actual seller financing addendum, it contains the rules for those exclusions. And if you have any questions on that, obviously give us a ring.
So like the example I was giving, the seller is going to give a second mortgage, $35,000, 20 years. That would fall within the rule, correct?
That would be fine.
So give us something that maybe would not be permissible.
Sure. So there are different rules for seller financing when the seller is either a person in a trust or a company or an LLC. So something that would run afoul of that rule would be a LLC that has done 5 seller finance transactions in any 1-year period. And in that instance, if we're preparing the mortgage, I'll probably tell you it's not going to work unless you have a loan originator involved, and good luck finding one.
Yeah, it's challenging, but luckily right now there's not a lot of seller financing going on. All right, FHA and VA. So so the big thing on this, and we're seeing in today's market, sometimes the sellers are not are putting in, I heard saying they won't accept contracts with FHA VA, which then I get the question, is that discrimination?
I get that question often too, and I really don't think so, but that seems like a line that I wouldn't really want to cross.
I would never recommend for someone putting in there saying, offers will not be accepted for FHA VA. I just wouldn't do that. I wouldn't want to try to get on that line or try to cross it. It's not worth it. Now, if in reality they get an FHA contract in with 3%, don't accept it. You don't have to tell them why. You can just say you don't have to. Now, of course, if they offer full price, you might have a problem, but you can play around with things like the closing date's not acceptable, the deposit, there's other things in there to talk about.
And I know the big concern with those is the statement of value that then sticks with the FHA or the VA on their file for 2 years and can basically become a little stain on the title, kind of in an underhanded way.
Yeah, so once they do the appraisal on there, whatever it comes in with, if a deal falls apart and then you get a subsequent buyer with FHA VA, that appraisal is there. So you're stuck with it. So that's kind of a negative on there. And of course, the other negative is the FHA VA inspection. So if that comes, you're going to have some problems. And the two, maybe the top 3 problems is a roof, because even though the roof is perfectly fine. And it's, by the way, it's not a hard and fast rule. Some VA inspectors will approve one that's got 5 years left. Some, I've seen them do it 3 years left. I've seen some of them that say it's 3 years left and they won't approve it. So there's a lot of discretion, and there's nothing to point to that says, oh, here, the regulation says. It's kind of in their discretion. And of course, then you've got your termite inspection that you have to have in there. But another thing that comes up, of course, the poly pipe, those VA FHA inspectors have a problem with that.
Cloth wiring.
Yep, wiring, the fuse box. Well, the fuse box now, even you can't get insurance.
With the Pacific Standard.
Yeah, yeah. Believe me, I just had renewal on one of my insurances, and I had the insurance company, well, my first insurance company canceled because the age of the roof. Okay, the roof is old. It's a flat roof, tar roof with gravel, but it doesn't leak, and it's about 20 grand to replace it. So I even offered the insurance company, I'll have someone come out, or I'll pay for your inspector to come out to show that it's sound, it's fine, all that. They just said no.
And I have some buddies that I went to law school with that practice in first party property, which is basically suing your own insurance company for failure to pay homeowners insurance claims. And they are having a whirlwind right now that they can't understand, where these insurers are dropping people with roofs that are 10 years and no signs of damage. And no one can figure out why. I don't know if the insurers are changing their underwriting guidelines because there's obviously a wave of roof claims in the state of Florida after every hurricane, and some of them are valid and some of them are not, but nevertheless, something that we're seeing a lot of.
Yeah, it's a shame because these insurance companies, and by the way, it varies from company to company. None of them are uniform. I saw a report recently about car insurance, how the same person went into 3 different companies and got vastly different quotes. I mean, like $1,000 difference. And I can tell you from my own experience of trying to shop around for this one, and it's not like 200 or 300. I had one quote that was $1,000 difference.
And I've seen a lot of insurance companies as well going under recently. It's kind of gives you the 2008 vibes again, doesn't it?
Yeah. Well, let's just hope we have a quiet hurricane season this year. Okay, you want to take this one?
Sure, I'd love to. Speaking of quiet hurricane season, for those of you that haven't checked, Hurricane Fred is supposed to hit us on Saturday?
Hit Florida, but not
yeah, Florida.
Don't get very nervous.
Well, we never know with the uncertainty with those things.
Yeah.
Okay, FHA financing, the purchaser is not obligated to complete the purchase or incur penalties unless they provide the written statement concerning value. The purchaser pays the loan expenses. The seller has some items that they need to pay, and the appraisal repairs as well. Any one of you that's done FHA or VA financing are familiar with that. Pretty routine, standard stuff. We won't linger on that too long. Want to take that one?
Sure. So the purchaser cannot incur any penalty or obligated to complete the contract if the purchase price or cost exceeds the value established by the VA. So you got fees in there. The seller pays the WDO, underwriting, doc prep. I think there might have been some adjustments on this recently. The purchaser's got to pay prepayments and escrows for taxes and flood and hazard insurance. So on the appraisal reels, if the cost exceeds the limit, and you can put whatever you want in there, you can put 0. You have 3 days to give written notice to the purchaser with your intent to pay some, none, or all of the costs, and then the purchaser can pay or cancel what the seller has said they're not going to do within the 3 days. So most people are doing 0 today, and most sellers are saying right up front they're not going to do any of them because of the market. So that's nothing surprising. All right, addendum F. This is our famous appraisal contingency. So do not use the additional term section to write anything about appraisals. You shouldn't be doing that. You shouldn't be practicing law without a license. And you're going to see when we show the examples at the end, some things that some realtors have been writing some big checks for their mistakes. So the one for the appraisal contingency isn't bad. That's there. The contract is contingent on appraisal of the property at the buyer's expense. They'll have to deliver the appraisal within 3 days when they receive it, and they can terminate the contract or they can waive it. Now, failure to appraise or timely notify waives the contingency. So we're going to get in at the end of we'll go through the standard ones. We're going to go through some of the alternatives that we've drafted on our website, and then you can use those in there.
I could hop back in on the appraisal. So I tell this to all our clients that the appraisal contingency is an addendum. That is one of 3 appraisal contingencies that we find in the contract. The first is obviously the addendum. The second is the normal financing period. You know, if it doesn't appraise within the loan approval period, then your buyer can walk. And the third is after the expiration of the financing contingency, the buyer can still walk, provided this term hasn't been altered or amended, if the appraisal is insufficient to meet the terms of the loan approval.
So it's in paragraph 8 of the contract.
Yep, and it's 8B7 subsection 3. And Barry, what are your thoughts on doubling up the appraisal contingency when you have a finance transaction?
I mean, it's not necessary to do it because, like you said, it's already in there, but people just feel comfortable doing it. My advice is to I mean, you can't give your people, should you do it on your own and take your initiative and start doing this? No. Now, if your client asks for it, you should probably say, look, I can't advise you. That's a legal matter. You know, if you're dealing with us, have the client call us. They maybe want to retain us to represent them, to show us what's, to walk them through everything. But personally, I feel comfortable what's in there and don't feel the need to use anything extra. I think people feel comfortable using addendum F, so I will use that. But I think one of the more important things that people don't remember when this comes around is if the buyer doesn't give you the loan approval within the time, it becomes a cash deal, but the seller has 3 days to terminate the contract. So what I look at it is that's a first telltale sign. If they don't give you loan approval, are they really going to be able to get appraisal? Are they on top of it? So you may want to cancel and move on at that time. But you know, with everything today, I feel more comfortable from a seller trying to get them to waive the appraisal, and we'll talk about that in a little bit. Short sale, luckily, knock on wood, there's not many of those going on right now. You know, it's interesting. I had an agent a couple of weeks ago that said, oh yeah, I'm doing a lot of short sales now. A lot of short sales. See a lot of short sales. I haven't had it. We haven't gotten many calls for it. There's lots of equity in people's property right now. So luckily that's not happening. If we have a downturn in a year or so, it might come up again, but it's not.
And I know some of the banks, just upon submission of an application, are automatically granting temporary modifications without even going through an underwriting review. So
yeah. So a lot of
we're seeing lots of modifications.
Yeah.
So it will be interesting to see if people start defaulting on those. But right now at this time, all the modifications are still.
Right. And don't forget, if your client says they did a modification, most of the modifications create another payoff required, because most of the modifications are done through HUD. That way, when we do a payoff, let's say someone has a first mortgage with Wells Fargo, and then they did a mod, the modification, we have to contact HUD, and it's a challenge because sometimes it's with them, sometimes it's with their servicer, and they do take much longer to get payoffs on, and sometimes can be very difficult to do. So make sure to ask, don't presume when you're at your listing appointment. Do you have a first? Have you done a modification? Do you have a second? Do you have a HELOC? Any other liens? Ask them all kinds of things like that. And then also, by having us do that free title search when you list, it will show up there too. So then we can get working on it. I'm not going to go through the short sale stuff because it's pretty self-explanatory and not very relevant right now.
We have quite a few questions.
Perfect. I was just going to say, do we have some questions? Okay, so what is the verbiage we should use when waiving appraisal? Also, what is the verbiage that states buyer agrees to bring the difference? Okay, we're going to go through that when we get to our addendum in the second half. If I have vacant land for sale, do we have a FERPTA for this? I'm not sure what that means, but If your seller of vacant land is a foreigner, yes, it is subject to FERPTA. So many times more often than not, the HOA will say that the fees due from the buyer will show up in the estoppel. I have to explain that's too late, that the fees are too high, could be problem. I agree with you. Like I said, personally, I went through this the other day. So sometimes what you do is ask your client for the coupon or the monthly statement. That will show the amount so you can confirm it. Try to ask for a supervisor and just say, look, I'm not asking for anything confidential. I don't want to know whether they paid the account, they're behind the account. I don't want to, just confirm for me. Is the lot, each lot assessed 125 a month?
And if there's any transfer fees or something like
Right.
that, I've never come into a situation where an HOA that has a CAM manager will refuse to give that. Now the one,
Except I missed the story, the one that I'm dealing with now.
Oh,
Condo. I called her, left a message, she wouldn't return. I sent her an email, she wouldn't do it. Had Flavia call her. She hung up, basically almost hung up the phone saying, well, I'm not doing anything. Supervisor said she'd help, emailed her, and I'm still waiting.
So what I do in that situation is I kind of go around them, and as I look in the court records to see if they have any active cases, and I just call their lawyer. Obviously their lawyer won't represent them for that, but the message will get across, I assure you. Back to the FERPTA, yeah, FERPTA does still apply to vacant land, regardless of whether there's a house on it or not. There are some ways, there are exemptions to FERPTA, green cards, things of that nature. But we go through all of that in our FERPTA class, if you're interested, or you can just give me a call with any specific questions.
All right.
Who can see
scroll up a little bit, David? Who can see the FHA appraisal if the deal falls through? Where is the appraisal record? It's not. The lenders have access to it. And if you as an agent, a buyer's agent, call, well, first of all, you'd have to know who the lender was that it fell through. If you happen to know.
I want to say that they have a central system that lenders that issue FHA approvals can go pull that from.
Right, they do, but it's nothing realtors can have access to.
Right.
And my point was that if you found out who the lender was and contact, they probably won't tell you. They won't tell you. I doubt they will. Okay, under FHA VA, if the appraisal is not satisfactory, could the buyer bring the difference? Yes. We have get that question off, and yes, they can. That
was a big question about a year ago when everyone was very, very nervous about that.
Okay, Stoppel, if there's a capital contribution or fees are different, would we be notified? Wouldn't we be notified? Well, the buyer won't be notified. It's the seller that should know these things. Now, it will show up in the estoppel, but like in my case the other day, the seller didn't disclose it. They didn't find out that the agent didn't get a copy of the estoppel. They get the closing statement. The closing statement shows the 1,500 capital contribution. And then the buyer says, well, I don't have enough cash. What am I going to do? So here's kind of the interesting question. The seller doesn't disclose the capital contribution. Does the buyer take the position, well, seller, you're in breach? So my position would be the buyer has the option to void the contract. So now, can they say, well, seller, you should pay it?
I get this kind of a lot too, and I don't have the addendum in front of me, so bear with me because I'm just kind of spitballing from memory. The only thing that's actually required under Florida statute to be provided is the first page of the HOA addendum. The second page is just extra, some nice little fluff. So if the second page isn't really filled out, you might have a good argument, to say something with respect to the contract, but I don't think you have a voidability argument under Florida statute. Now, I don't recall off the top of my head whether the capital contribution is in that first page that is required to be provided. I think so.
On the break, we'll pull it and double check on that. New insurance for Florida came out today. My email came from Shile Insurance. I don't know what that means.
I think
new
they
insurance. Okay. New insurance came out. Okay. Solar panels. How do we as agents find out if there's money owed or paid in full? Recently, year and a half, sold property solar, didn't attach lien. Bill recently, obviously, title pulled lien search, and it was blank. They filed a year earlier today, but had a year to proceed. Property sold 3 years ago. Okay. Well, first of all, when title pulled it, if there was a UCC lien attached, they should have addressed it at that time. But solar power is these panels is a lot of stuff coming up on this. So there's all kinds of things. Are they leased? Are they financed? Is there a lien? Is there not a lien? All kinds of things involved there. So I am so glad you asked. In the end, we'll go through this. We got so many calls on this that about 2 or 3 months ago, we drafted an addendum. So we give it out for free. It's on our Realtor Resource Center, and it goes through and asks the people to check off. Is it paid? Is it, it goes through all of those things, and we'll pull it up at the end and kind of run through that with you. All right, how do you waive the appraisal contingency? Again, we'll get into that in a little bit of how to do that with some addendums. If there is a date on the appraisal contingency, the appraisal is completed after the date, does the buyer forfeit the escrow deposit if does not appraise that purchase?
So the answer is maybe, but it doesn't depend on that term of the contract, right? If the buyer misses the appraisal contingency addendum window, then yeah, they can't terminate and get their deposit back under that contingency, but then we can jump over to inspections or financing or something of that nature. So it isn't like you missed the deposit or you missed the appraisal contingency window that the deposit just poofs goes to the seller. No, we look at other things as well in the totality.
But the argument can be made because the addendum does say that it would be waived if they don't.
Oh, it waives all the other contingent.
Right. So it possibly could be, depending on the circumstances, that, probably if you used addendum F and they didn't do it in time, then it's considered waived. And we had that a couple of years ago where they literally, the buyer gave the appraisal a day after, and they kept arguing, saying they try to blame it on the buyer, saying that the appraisal was dated prior to the date, but they held it. And I thought it was a ridiculous argument. The buyer's like, yes, it was dated the day before, but they didn't give it to me. The bank gave it to me on Wednesday. They finished it on Tuesday. It was dated Tuesday. The bank gave it to me on Wednesday. I saved it on Wednesday. Tuesday was the date, but they didn't hold it. So it was kind of a weird argument. And
I'm a bit confused about the three-sided appraisal contingencies contained within the contract. Okay, yeah, let's talk about that. You're not going to find 3 paragraphs that say appraisal contingency. One of them is the addendum. Obviously, that's number 1. It's pretty obvious that the addendum is an appraisal contingency.
That's addendum F.
Right. Then we have the financing contingency itself. Pardon my garbled language there. In the financing contingency, obviously, if during the loan approval period you can't get a loan because of the appraisal, then you have the right to terminate under the financing contingency, which again, you're terminating because of a failed appraisal. That's number 2. Number 3 is if you look a little bit further down in paragraph 8, it's paragraph 8B7 subsection 3, that comes about after the expiration of the financing contingency. If after the expiration of the financing contingency, a loan approval has been obtained, but the appraisal obtained by the lender is insufficient to meet the terms of that loan approval, then the buyer can still terminate, notwithstanding the fact that the financing loan approval period has since passed. So that's where we get the 3.
Yeah, and a lot of people have a trouble with the first one. I mean, the second one there, because it can be done for appraisal, or it can become they get turned down.
Credit.
Right. So it could be anything, including that. Okay. All right. But we don't have a FERPTA addendum. Right. I had someone the other day that they submitted a contract with a crisp FERPTA addendum. And I said, what's this crap? And the listing agent said, the buyer insists that we must have that FERPTA addendum, or their offer, they will not submit an offer, or if you counter and cross it out, they will not buy the property without that FERPTA addendum. So I said, this is a telltale sign that I don't know if it's the buyer's agent or the buyer has no clue. So I pointed out to them that their FERPTA language is already in the pre-printed as is and regular FAR bar contract, and what's in the crisp addendum would just repeat of it, and they kept insisting on it.
I believe that language is in the vacant land contract as well, but I don't recall. I think that's what the question is.
And we don't have a FERPTA addendum. Is it now in the property contract? Well, it is in the one for the FAR bar. Is it in the vacant land? Not sure. Again, I'll check that for you on the break. if vacant lien is owned by a foreign seller, or if someone wants to really get around FERPTA. So if the vacant land is owned by a foreign seller who inherited it from a family member who's living in the US through probate, is he still subject to FERPTA?
So I'll take this one. I get all the FERPTA questions. So let's talk about it. Again, we do have a full FERPTA class, so I do highly recommend that. And I'm going to caveat what I'm going to say with the fact that we're not tax lawyers, we're real estate lawyers, and accountants should always be first consulted with respect to FERPTA. Under this, I would say probably so. It doesn't matter how he acquired it as long as he acquired it. And if he is now a foreigner selling it, that is the disposition of a US real property interest subject to FERPTA. Now, that being said, if he is in fact a foreigner, there are ways accountants can get withholding exemptions to show that there is no capital gain or something of that nature. One of the good things about inheriting property is you get what's known as a stepped up basis, which alters the tax liability based upon values at times of death and things of that nature. Won't get too into that lovely mathematical calculation, but in the event the disposition results in a net gain to the seller that's minimal or low, an accountant might be able to obtain a withholding certificate. Give me a call on that, because I have a feeling you're the same individual that asked the other FERPTA questions, and I can probably walk through it with you for 10 minutes.
Someone put on there, they've heard that now it's 4 months, not 2 years. I mean, maybe one of our lenders that's on could chime in on that, if there's been a change on that, to let us know. An FA appraisal sticks to the home for a period of time. Can the title company see that appraisal? No, we can't see them either. What do you mean by it sticks to the home? What we mean it sticks is if I go to buy his house and use an FHA, and I get that appraisal or that report that shows the roof's no good, and then I drop out, and then buyer B comes in, and for FHA, as soon as the lender puts it in, that's going to pop up, and they're going to see it sticks with it. It pops up in the system. When they go to the FHA VA underwriting software, it will be in the file associated with that property. And by the way, getting back to that thing there, if someone, even if we had a copy of the appraisal and the deal fell through, we can't give it out. We have privacy laws and confidentiality. So the only ones that have access to that is the lenders. If a client submits an offer without appraisal contingency, they need to be prepared on addendum for that transaction.
I think what you're saying is, in the event you don't include appraisal contingency addendum F, do you need to prepare a separate addendum concerning that? The answer is maybe. Usually not. We don't want you guys preparing addendums. If your buyer is in fact getting financing and there's no alteration of paragraph 8, for example, you guys aren't crossing through anything in paragraph 8, then ordinarily what Barry was saying is no, you won't need something additional because it's already contained in, like I said, those other two financing contingency kind of appraisal contingencies.
Because the big thing we see is people just write in the additional terms, sale subject to appraisal of the property. Okay, that's foolish. When's the appraisal? When's it to be done? What happens if it comes in early? I mean, the who, what, where, and when are not there. So you should just never put, again, never write appraisal language in paragraph 20. How long is it? Okay.
I think. How long does the FHA appraisal stick? I'll be honest, I really don't know. That's more of a question for a lender, but some of our attendees here are saying they think it's 4 months. It used to be 6.
Okay. Good. Okay. All right. So what we're going to do is we're going to take a little bit of a break while you grab a cup of coffee. We have our sponsor today. Again, it's Michael Wallman. So if any of you aren't familiar, Michael's a great financial planner. Now that you guys are making buku bucks in this market, save for your retirement, do some investing, market's good, start accumulating wealth so that when you retire, you'll buy that private island, invite me to. And so tell them what kind of good stuff you have.
Awesome, awesome. My name is Michael Wallman. I'm an independent financial planner. I'm going to talk a little bit about today tax and financial planning for the real estate professional. So what I want to talk about again is independent financial planning, I work in a holistic method, which is I work with accountants, I work with attorneys, I work with insurance folks. So I do more comprehensive financial planning. And when I talk further, I'm going to talk about the relationship with your accountant and how the involvement is so important. So today, as Barry said, y'all are going to make a lot of money. You've been making a lot of money. And what does that mean? It means you pay a lot of tax. Okay. So what I'm going to talk about is how we can ameliorate your tax liability, as well as at the same time save for retirement. So I'm going to talk about a vehicle called the solo 401k. Individual 401k, it's also known by. I'm going to open up, if need be, any questions in the chat box. As I talk, please feel free to type in any questions you might have. So the individual 401k, what is it? Just as if you were at Darden or Disney, you have a 401k. The individual 401k, as it sounds, is for owner only, no employee, plus a spouse. If I have time, I'm going to give you a case study on a spouse. So the individual 401k, just as if you were at Darden, you have the opportunity to put money away, save for retirement, reduce your income, thus reducing your taxable liability. Same concept. Individual 401k, you are, however, both the employee as well as the employer. And what does that mean? That means the following. The individual 401k has a very high contribution limit, depending on your age, up to $64,500. That is the maximum you can put into this individual 401k. You can also, in the individual 401k, contribute to a Roth. This is very strong, as it's the only vehicle that I can say, based on your age, you could put $26,000. No other vehicle can I say you can direct $26,000 into a Roth. Okay. As the employee, you're able to contribute up to $26,000, of which all can be directed to a Roth. Imagine putting $26,000 in a Roth for 10 years. So the individual solo 401k, high contribution limit, it has a Roth component. And the third piece is how you can create liquidity from a retirement account without the 10% penalty and without income tax. The solo 401k allows you to remove funds without tax, without penalty, through a loan. You are borrowing the funds from yourself. So you have the maximum amount you may borrow from your solo 401k is $50,000 if you have a value of over 100 or 100. Value, half of maximum is $50,000. It is a loan. You are paying yourself back plus interest. Okay, again, you are able to remove funds from the account without the tax penalty of 10%, plus no tax as income. It is a loan paying yourself back plus interest over 5 years. Now, the loan feature, if the funds are used for a primary residence, it now becomes a 10-year loan, okay? So the individual 401k, high contribution limit, the Roth component, and the availability to remove funds without tax or penalty. Again, you're paying yourself back plus interest. The relationship that I talked about a moment ago with your accountant, because I'm going to go over a couple of scenarios. If you work closely, and this is how I do it, okay? I work with 3 accountants in the Central Florida area. Why do I work with them? Because they pick up the phone, okay? I can call Candy, I can call Tiffany, and they will answer the phone or call me back. That is immeasurable, okay? When I call an attorney, if I call Barry, he will pick up or return the call. That is invaluable. So when I work in the holistic program platform, I talk about the relationship with the accountant, because here's a case study. Client makes $154,000. As the employee over age 50, he is able to contribute $26,000. As the employer, the individual 401k allows you to match up to 25%. 25% of 154 is $38,500. Together with the employee contribution is $64,500. Again, the maximum is $64,500, comes from the employer, $38,500 max, and $26,000. The other component is I can call Linda or Tiffany or Candy and say, I have Bobby, I understand he made $154,000. I'd like you to run 3 numbers. I'd like you to tell me if Bobby contributes 0, what is his tax liability? And she'll crunch some numbers and say, oof, he's going to owe a lot of money, Michael. And I'll say, okay. I'll call Bobby and say, hey, Bobby, you got a tax liability of X. However, remember the solo 401k, we can contribute up to $64,500. You make 154 and you put in that maximum. You're now, Uncle Sam is now going to tax you at this lower amount. 154, you put in that 64.5. This is the new number you're being taxed on. That's a savings of close to 20, 30%. Very important, the phone call to the accountant to get those numbers. Well, you know what? I'm going to ask her to run it a second time. Tell me what the liability would be if we just do the employer contribution. And I take the employee and I put it in the Roth. She's going to run the number and say, okay, well, instead of it being X, it's Y, and see if that's palatable. I call Bobby and say, Bobby, you know how strongly I feel about the Roth. Everybody loves the Roth. Won't help you with taxes today, but what happens when we pull it out? Comes out tax-free. The conversation now is, hey, Linda, he's going to do the 38.5, and I want him to do the 26. And she'll say, oh, that's great, Michael. Hold on a sec. You know, he's close to a tax bracket. Why don't you put 16 in the Roth, give another 10 to reduce your income and defer. I'll bring him under a bracket, save him even more money. Sounds good. So that's the relationship with accountants, relationships with insurance folks, talking about life insurance and so forth. Attorneys, the relationship there. I'm going to go ahead and take a question or two. What if I already have a 401k, Roth IRA with other company I work for? Would you still open a solo? If you currently work at a Disney or another company that has a 401k, unless the businesses are unrelated, I work at Disney as a character, I sell real estate. Your Disney plan, okay, you get the match, you got what you put in. If you put in the $26,000, we're not able to contribute to a solo. How is the different between a SEP and an IRA, SEP IRA. The difference between a solo and a SEP are two major issues. One is the ability to borrow. SEP IRA, you're not able to remove the funds unless you have the tax penalty and of course the income you pay tax. The other is the ability to remove funds from the retirement account. In a SEP or a simple or an IRA or a Roth, you remove funds, you're going to pay tax, 10% penalty if you're underage, plus income. How much does it cost to set up the individual? The individual 401k, if you are a do-it-yourselfer and you like to go to a Fidelity or a Vanguard, low cost, and you'll be able to talk to Jane, the Time Life operator. Now, for the boomers, we know who Jane, the Time Life operator was, Barry Smirk. So you can do it at a Vanguard, Fidelity, very low cost, or you work with a planner that would charge a fee. What I will do is offer a 30-minute free consult. Please take advantage of it. You give me a call, I take some notes, I send you an email back. I make sure you're on the right path at least, okay? Any other questions I do not see? Again, please call. My information's up. I'd love to talk with you. 30 minutes, my pleasure.
I got one for you, Michael. I got a quick question.
Yes.
Would you recommend that agents, well, let me pose the question this way. What is better? Should an agent open a self-directed IRA on like E-Trade or something, or what do they get by going to you instead of doing that?
Well, there's the value add, obviously the value add. Self-directed IRAs are different. Self-directed IRAs are where you're buying a piece of property inside. That is not a vehicle I work with, but it is out there. That's a self-directed.
Cool.
Awesome. And Barry,
Great.
again, I
Thank you.
appreciate the time.
Yeah, guys, take advantage of that. Get the 30-minute on there. Tell Michael what your situation is. He'll tell you if you're on the right path, make some recommendations, you know, see where you can go. It's just good business sense, guys.
Awesome.
Good. Well, thank you.
Thank you.
Michael, I'd shake your hand, but I got a little bit of
Okay, so I got answers to two questions. The vacant land contract we looked does have the FERPTA language built into it. In paragraph, what was it, 7?
7F.
7F. Okay, then the other thing is on the capital contribution. So on the addendum, you know, there's 2 pages to it. One is the statutory, the first page. The second is they break it up into part B.
I'm sorry,
and
that is 10F on the vacant land.
Oh, 10F on the vacant land. So on the homeowner's disclosure, it says buyer shall pay application, initial contribution, and/or membership or other fees charged by the association pursuant to its governing documents or applicable Florida statutes. If applicable, the current amount is, and then you fill it in. So again, it's so important to get that information because look, we don't want to ambush people. We want everything open. We want it to be transparent. So you've got to, a lot of times your seller may say, oh no, there's no capital contribution. Well, that could have been 10 years ago when they bought, but maybe there is now. So send that inquiry to the manager. Now, sometimes too, if they don't respond, you have some questions. Sometimes you can ask us and we can look it up if we did another closing in that subdivision and just tell you what the last one was, and that will kind of help. It's not a guarantee because things can change, but it's at least some good direction on that. Okay, so the next one that gets missed a lot is if you're using the regular contract. So in there, it has the pre-printed for repairs, 2%, or we put it fill in the blank. But you've got to remember that if you use the regular contract, which is very rare, that the buyer is locked in if the repairs are under that amount. So I had once a doctor, she bought the property. The realtor did not explain to her the difference, the advantages or disadvantages of using the regular or the as is. So she just used a regular, put in there $10,000 for repairs. There was some cracking in the stucco and the windows were leaking. The buyer got an estimate of 9,500. The doctor buyer said, I just don't feel comfortable. I just don't think it's right. I don't have time to get other estimates. And I kind of went through is, did your realtor explain why you're using this contract? And then if you use this contract about using addendum L, she goes, she didn't tell me anything. She basically filled it out, stuck it in front of me and said, sign it. Please don't do that. So she's got an action with her agent on there because there could be some issues on there. So again, if you do use the regular contract, use addendum L, because addendum L mimics the language of the as is that said buyer for any reason whatsoever in their sole discretion can cancel the contract. So even though it has the 10,000, there's 9,000 estimate, but the buyer wants out, they can get out. So please, please, please make sure you use that addendum L.
Lead-based paint. Obviously, this is coming up when we're concerned with houses built or constructed prior to 1978. If you've got a house built prior to 1978, you not only need to give this disclosure, it's required under both federal and Florida law. You also need to give the cute little lead-based paint warning pamphlet. I don't think I've ever received a contract come across my desk with that pamphlet actually in there. And I get it that in the addendum, the buyer's signing off saying, yeah, they got it, but make sure they got it.
Yeah.
You can download it from, I think, the EPA's website, HUD's website, and you can just Google lead-based paint warning statement and you'll find it in 10 seconds.
Yeah, yeah.
So be sure to do that if we're talking about pre-1978 construction.
Okay, S, lease purchase, lease option. Again, in today's climate, we don't see these often. We've done tons of them over the years. Now, why would somebody want to do this? Well, let's say they're selling to the buyer, and usually it's the buyer is credit challenged, or there's some reason they can't get a loan, and the seller is willing to lease it to them with either the agreement to purchase it at a certain date or give the buyer the option. Now, obviously, if we're representing the seller, we'd like to use the lease purchase. Hey, buyer, I'll sell it to you. You can rent it for a year, and at the end of the year, you're going to buy it. Or the option is, hey, buyer, you can rent it for a year, and after a year, if you want to, you can, but if you don't want to, you can't. Now, why would you maybe not want to use the lease option for the seller? Because if prices go up, they obviously don't buy it, then you can put it on the market. But you can also do that with the lease purchase. So if I'm representing the seller, I want a lease purchase. The buyer, I try to do it as a lease option. Now, remember this agreement, I recommend you never use it. And if you have this situation, I don't even recommend you use the FAR bar contract. This is an agreement to make an agreement. All right, so I have to do it within 5 days, the effective date. Why bother? Why waste your time? Go
ahead, sorry.
Well, go on our website. There's a one-page little form you can fill out in 5 minutes. You send it to us, we prepare it. So what I've seen some people do is they'll use the FAR bar contract and then they'll use the FAR lease. Oh, what a nightmare. First of all, that FAR lease is horrible. You should never, ever use that thing. It's garbage. So again, what we do is one document that's got the purchase agreement and the lease in the terms, everything all in one. And then the other thing we do is we have this discussion with you because it's not addressed in the contract or using this addendum is your commissions. So if you're going to lease it to someone and then a year they're going to buy it, why should you wait a year for your commission? So let's say the buyer is putting down a $25,000 deposit under the purchase or $25,000 option. It's a non-refundable fee. So think about this. First, seller, if I'm the agent, seller, you want to do this, that's fine. But customarily, we charge a leasing fee of 1 month's rent. He may say, great, that's fine. Do an addendum to your listing agreement, put that in. Or you might have the discussion saying, okay, we'll do that, but they're giving you $25,000 up front. I would like to get $5,000 of my commission out of that $25,000, the balance upon closing. Seller may say fine, but the seller may say, well, wait a minute, what happens if it doesn't close? Then you would say, so I have some agents go, well, I've earned that, we're done. Or some agents will say, of course, if it doesn't go through, I will relist it, put it on the property, and that $5,000 will get credited when we do sell it. So keep that open mind about that. Don't cut yourself short, because you could get some cash flow coming in up front and get a leasing fee. Maybe the seller may be moving out of town. You may say, hey, would you like me to manage it too? If you can manage it. So again, these things are out there, they're available. So just let us know if you need help on that. Anything else to add on those?
Nope, yeah, I took the words right out of my mouth. Don't use the FAR lease and make the closing date on a FAR contract a year after. Just avoid that.
So pre-closing occupancy, we do see this often. Okay, now you got to remember, this is again is an agreement to make an agreement. The lease shall provide that paragraph 11, 12 are no longer applicable when they take possession. The buyer accepts it in their current condition. But again, this is an agreement to make an agreement, and it says in there who pays for it. So you take care of this up front. Don't wait till the last minute. Now, very often, well, nobody wants to pay for it. Well, really, if you're going to do it, that's like no one wants to pay commission. I understand that, but we all work for a living, so we need to be paid. So they've got to do it, and I think we charge $295 for them, $395. So, and it's the same token when it's a post-occupancy agreement. Now, be very careful. If you have an agent that says, oh no, we don't need an attorney, I have one to use. Okay, that is the practice of law without a license. And if the realtor said, oh no, we're just going to fill in the names and the amount. No, you can't. You cannot do that. You can only do that on the FAR bar contract, fill out the blank forms, pre-printed form, or the
And
lease.
some agents do try to use the FAR lease. I don't recommend doing that either, because you need to create a bond or a connection, if you will, between the actual closing and the document that's going to constitute the pre or post occupancy agreement. And simply using the FAR lease misses that connection.
Sometimes it doesn't address things like who's going to be responsible for maintaining the property, who's going to be requiring insurance, making sure when they move out. The other important thing is there should be a security deposit. If you're letting a buyer in early, get a security deposit, because if it falls apart, there's damage, you want that. If it's a seller that's staying in after closing and they damage it, there's got to be money there. It's only fair. Make it reasonable, and you should always get a security deposit, and you should make sure there's proof of insurance.
Last thing I'll mention on here is there's somebody in town, can you go back one for me?
Yeah.
Who will remain unnamed, but has been using this addendum as a sneaky way to get his buyer/sellers out of contracts as a fallback. If you look at the very last bullet point we've got up there, if the lease is not agreed to by and between the seller by a certain period of time set forth in that addendum, either party can terminate. And so what this person was doing was using this addendum and then never agreeing to any lease for sole purposes of, well, we got our offer in, we couldn't agree on a lease, we're walking now because we found something better. So just be on the lookout for that. I don't think many agents will do that. I do think that's a good faith and probably an ethics problem, but nevertheless, be vigilant against that.
Yeah, be on top of the game. That's the thing. All right, kind of the same thing on the post delivery. It's an agreement to make an agreement. States when the seller will retain possession, monthly rent, maintenance obligations continue until the buyer takes possession. And then again, if they can't agree, you can terminate. So get ahead of the game. If you know this is going to happen, have us do it right away and get the parties all signed up. All right, V, we do still see this. If you want to go ahead and go over those terms.
Yeah, so this is the sale of buyer's property addendum. This is where you have a buyer that's currently a seller in another transaction. And that addendum gives the buyer a specific set of time with which to go ahead and sell their property or terminate this contract because they are unable to do so. So obviously it requires that the seller gets a copy of the contract for the sale of buyer's other property with the relevant information obliterated. We don't give out names or things of that nature. If the sale of the buyer's house doesn't close by the specified date in the addendum, the buyer can deliver within 3 days of that specified date, notice to cancel or waiving that contingency.
So one thing to be careful on this is, and this just happened to me a couple of months ago, is give some wiggle room in there. because if your buyer is supposed to close, let's say on August 15th, I would recommend putting a cushion in there and make it August 20th, because just in case this exact thing happened, the guy put in June 15th, and then he was going to close on the new house down here on June 30th. What happened at the last minute is a lot of states up north require an inspection by the fire department and a CO, a new CO be issued before they'll let it close. Well, this guy didn't realize that at the last minute, he bought the house new. It didn't have the proper permit closed out for his pool. So that took a while, and it didn't have the right smoke detectors required. So it was gonna be delayed after the time, and it created a snowball. And then the seller was like, well, I can get more money. Maybe I'm not going to extend it. So sometimes if there is a concern, ask us too. We may put some special language and additional terms. For example, we may put a term that if the buyer's home is delayed through no fault of the buyer, then there would be maybe there'd be an automatic 7-day extension. We can put something in there to work things out, to try to anticipate some of these things so you don't fall down. And especially with a buyer's agent, you do lots and lots of work and then have the whole thing fall apart. Backup contracts, of course, we see lots of backup contracts now, and that's a big thing, or multiple, because of multiple offers. So the backup contract, it's subject to termination of the prior executed contract between the seller and a third party. It's after the primary is terminated with notice to the buyer that contingency is removed and the backup comes into primary. The effective date will be the seller delivery date, and the backup contract can terminate this contract prior to termination of the primary. So you can put things, of course, in as backup. Sometimes, I'm not sure, maybe you guys give me some feedback. Are people in multiple offer situations now, are listing agents keeping a backup just in case it falls through? Or is the market right now is they don't even want to put it in because they're off looking for another one, and hopefully they'll get that before this one comes through. So
I've seen more of the escalation addendums than I have the backup addendum.
So I'm just curious if some of you chime in if you're seeing the backup being used a lot. Kick out clause?
Yeah, so this is the seller has the right to enter into backup contracts. This is basically the FAR bar's version of an escalation addendum. Seller is going to give the buyer a copy of those backup contracts, and the buyer is going to make an additional deposit. The one thing I don't like about this, and I would normally defer to a regular escalation addendum, is this increases the amount of a deposit, not the amount of the purchase price. So just something to be aware of.
Yeah, I don't see people using these.
Now, the one good thing about it is you make the additional deposit and you waive all contingencies, if I recall correctly.
Yeah. So why is the seller attorney approval and the other one is the buyer's? Very, very rarely in today's market see this. Why? Because a seller would be like, why am I going to wait for your on either side, wait for your attorney to approve it when I got 5 other offers? So the good thing for the buyers, and again, you guys have heard us, we got a great program. It starts at $995, and it's a buyer's rep. We'll write the contract or review the contract. If it goes back and forth, same thing. After inspections, we'll do, if you need a repair addendum, we'll draft that. We do what's called a title objection letter to the seller's title company to get you a better policy, and review all the closing documents and take off junk fees if they're on there. And we also can represent the seller on the seller side for similar services on there. So if your buyer does want to have their attorney look at it, what I would suggest is retain us before they go out and look. And especially if you've got buyers from up north are used to having an attorney. And once they retain us, an attorney will be assigned to them. And that way, if you go out on the weekend and you need us to do that over the weekend, we'll be available to get that done for you. Okay, here's the fun part, folks. Let's do this real quick. Is there questions? Okay, good. Huh?
No, not really since we've done it.
Okay, so if you have any questions, start putting them in. But now we're going to start looking at our samples. David, is there a way to make that a little bigger?
I don't think so. I can read it.
Okay.
So this one says, this is additional terms. Closing date shall be 15 days after the ACOE wetland approval for the assemblage property located basically behind this property. The issue that we have with this is when is closing? Can anybody tell me? And the problem is 3 years have passed under this contract, and the buyer comes back and says, well, I'm ready to close now. And it's arguable whether he does or does not have the right.
Right, so you can't have open-ended things like this. What happens if it took them 5 years to do it? The seller's supposed to keep it off the market? Is there any status? I mean, if we were writing this, it would have a drop dead date. It would have something to the effect is that the buyer shall be obligated to submit its application within 15 days. Keep the seller appraised. If it gets rejected, then the seller has the option to terminate. So it can't keep going on and on forever. So open-ended things, be very, very careful of stuff like that. Okay.
You want me to read this one for you?
I don't know.
The buyer has completed the home inspection and is willing to move forward, provided the seller contribute $20,000 as a closing cost concession. The closing to be extended on or before 6/25/21.
Wow. The buyer has completed
the home inspection. And is willing to move forward, provided the seller contribute. Wait, no, I see the error. Is willing to move forward, providing the seller contribute $20,000 as a closing cost concession.
First of all, I'm not sure what it means. And is willing to move forward, providing the seller contribute $20,000. I think what they mean is they want the seller to pay $20,000. Now, first of all, closing costs. I mean, you need to be more specific. It should say, what about your prepaids? It should say including prepaids. It says they're willing to move forward.
Not they are.
Yeah.
Not they're terminating.
Right. So what does this mean? What it should mean is if this came back after the inspection, it should be the contract is hereby amended to provide as follows. One, seller shall pay $20,000 of buyer's closing costs and prepaids. Okay, you got to make sure first there's going to be $20,000 worth there. Because you want to be the closing extended on or before 6/25. You remember from our last
I remember
class.
why we put this on here too. Is the buyer had 9,000 in closing costs, nowhere near 20.
Oh, yeah. So the agent did this without even checking with the lender to see if there was that. The buyer would have lost $11,000 worth of benefit. And again, closing costs on or before 6/25. Never use on or before. Closing will be on 6/25. If you got to move it up, ask each party to sign an addendum. Never want to use that. All right. Whoops.
Oh, Dave moved it for you.
You moved it for me. Wait a minute. I think there's another one in between. Yeah. Okay. So here's this one. As per inspection report released to buyer, buyers requesting $2,000 credit towards the following issues raised in the report.
Couple issues with that. A credit towards what? If it's a credit towards the purchase price, the lender is probably going to take issue with that. If it's a closing cost credit, again, lender might still take issue with that, but we just don't know. And Barry's going to harp on the requesting language there, so I'll let him do that.
Yeah. So you sign this, and they come to closing, and they go request denied.
When writing these things, we don't use indefinite language. We don't use might be, may. We use shall. So this should have said, I would remove that entire first section and just put at closing, seller shall give to buyer a closing cost credit in the amount of $2,000 to be applied at closing towards the items listed in paragraph 8 of the contract and buyer's prepaids, comma, if any. Period.
And it's also kind of ambiguous because it says, towards the following, but then it says fix it. So are they trying to say the seller's supposed to fix it or the money's supposed to go towards it? I think they meant the money's supposed to go towards it. Again, look at our sample addendum for repairs if you have a repair, but use definite language.
I hate seeing references to the inspection report. Be cleaner, be clearer. Don't say paragraph 12 of the inspection report. We have a repair addendum.
Right. So let's just say in this case, they're really not looking for the repairs. They just want the credit. Why do you need to put all this junk in there? Okay. Why does it say as per the inspection report released to the buyer? You mean it was released to the buyer? I never know when an inspection report's not released to the buyer. I mean, if I buy a house, they do an inspection, they don't release it to me. What do they do with it? Okay, this should have been simple. It should have just been seller shall provide buyer a credit of $2,000 towards closing costs and prepaid. The cover email should just be to the listing agent. Dear listing agent, please be advised we've completed our inspections pursuant to inspection paragraph. Buyer hereby terminates the contract as the inspection was not acceptable. However, attached, please find an addendum. If the seller will sign this, giving the buyer a $2,000 credit, we will be happy to proceed on with the contract. So
yeah, basically the gist is if you're running at the end of that inspection deadline, don't let that inspection deadline pass without terminating the contract because you're waiting on somebody to execute an addendum. The better way, like Barry was saying, is terminate the contract and then revive it later at the same time, just to protect the escrow.
okay, our next one.
Oh, yeah.
Go ahead. You ready?
Buyer and seller agree that buyer will agree to pay $750 above appraised value at the time of closing to the seller. If I was a buyer, I might love this. I might hate this. This can go a million different ways. Let's say this was under contract for $200,000. The appraisal comes in at $50.
Well, let's do what really happened on this, okay? Buyer's agent called me and said the seller is terminating the contract. I'm like, okay, what's going on? She says, well, we had this clause, purchase price is $200,000. The appraisal came in at $185. And the seller said, I'm canceling. I'm not selling it for $185, $750. And the question was, is the seller obligated to sell it for $185, $750? The answer is that's what he agreed to. Okay, it doesn't say, what it should have said is some sort of language of 750 above the purchase price if it appraises. There should have been more language involved in there that took into account.
We like to see floors and we like to see ceilings,
right,
depending upon who we're representing. We'll pay 750 above the appraised value, which shall not exceed the purchase price and shall not be lower in any circumstances than 250,000, right? But floors and ceilings.
By the way, what ended up happening on this one, the seller ended up selling it to him because we said we were going to sue them for specific performance. They ended up doing it that way. Don't know whether, I can tell you the buyer's agent did not contribute any of their commission, but the buyer's agent did tell me the listing agent did help the seller out due to this issue. Okay, our next one. Seller agrees to repair and replace the following per the inspection report. Okay, so it lists out the things that are in there and then says buyer shall have the right to reinspect all repair, replace items to make sure they were done per the above mentioned verbiage. Should buyer and seller not agree on the finished work per the above mentioned verbiage, buyer has the right to cancel and receive their full escrow money back.
Great for the buyer, awful for a seller. That gives the buyer the unilateral right to say, well, that caulking looks a little shaky. It's a little tinted. It's not, a perfect, beautiful straight line. I'm canceling.
Yeah.
Sorry that you spent $15,000 on the repairs.
Well, the other thing too is who's doing these repairs? So the seller says, I'm gonna get my handyman to do it.
You know what, I'll do it. I'll do it.
Yeah, sometimes the seller to himself. Electrician, changing out boxes. This needs a plumber, an electrician, termite company.
And permits for every single one of those.
Yeah, again, bad. Leaves things really, really open and lots of bad issues in here. Okay, take the next one.
The seller to pay 1% of buyer's closing expenses. We are assuming that they meant to put 1% of the purchase price towards buyer's closing costs, but instead put 1% of buyer's closing expenses, which were, that's probably what, $15, give or take, depending upon the deal.
Yeah, so let's say that let's say that the closing expenses, I don't again what that is, that's not a defined term, but let's say it was $5,000. So now you got 1%. Thanks
Yep.
for the $5.
Yeah.
Yeah, $5.
Or $50.
50. No,
We're
50.
lawyers, not mathematicians.
Okay, then the next thing on there, buyer must provide proof of adequate funds for purchase and closing expense by 4/18. What do you mean provide adequate proof of funds? Again, property sold as is, buyer will make no repairs. The buyer will make no repairs? I think they again meant the seller, because like on the top, you see they put buyer to pay 1%. They fixed it, but they didn't fix the last one to make no, again, it's but you don't need to put things there. It's governed by the contract. The other thing is about this adequate funds, folks. When you're sending over proof of funds, make sure you look at it. I prefer for the buyer that their lender, that their banker just writes a letter on letterhead that says, this is to confirm that the buyer has more than sufficient funds to meet the obligations of the purchase price of $500,000. I'd rather not give someone's statement, but if you do, make sure you obliterate and with a Sharpie get rid of their account number, their social security number, anything else that's confidential in there. I had an agent the other day that sent the guys 27-page Raymond James account statement that had his social, it had all kinds of confidential information in it. It was just, I said to the agent, what did you do? She goes, I didn't even look at it. I said, I just hope they don't, you better tell your client, be careful of identity theft, because who knows where that social is right now. So be very, very careful of stuff like that. Okay, the next one. Seller financing terms. Buyer to pay seller $125,000 per month on the first of every month for 11 months. Buyer to also pay seller interest in the amount of $2198.12 per month on the first of every month for 11 months, comma, seller.
That's my handwriting trying to fix the addendum. So you can ignore the handwritten portion. I recognize that immediately as my handwriting.
So again, don't use this. Use the addendum that's there. It have the interest rate. It will have, if there's a balloon, it will, you got to put the rates and the stuff in here. So this is not acceptable. Use the addendum. It's good. It'll work really well. Okay. So here's an interesting terms on here. 2019 property taxes to be current by seller upon closing. Is that a necessary term? Because if not, the buyer would probably have to pay it, right?
Yeah, we already prorate that under the terms of the contract.
Okay, so first of all, it's already written in there that any past due taxes to give clear title would have to be paid. So in this case, the 2019 taxes would be paid. And then the current year would be prorated. Again, it's not necessary. It's in the pre-printed contract. Then it says an amount of $10,000 to be set as a hard money loan for the moving of property to be delivered vacant upon closing and to be determined by the walkthrough prior to closing.
What this was is one of the parties was giving a loan to the seller to cover moving expenses, but it just isn't written correctly.
So then it goes on, an amount of $10,000 to be drawn from the purchase price as a hard money loan from the buyers to the sellers for the moving of the seller's items that are currently remaining in the property. The drawn amount of $10,000 will be released to the seller from the buyer's selected title company within 3 days of execution of the contract signed by buyer and seller.
what they really meant to do was an escrow agreement holding back 10,000 of the proceeds, or actually, I really don't even know.
Okay, so actually, that would have been one thing if it was the proceeds, but in actuality, what they were trying to do in here is, once they went under contract, they were going to give them 10,000 up front so that they could move, so that at the time of closing, the house would be empty. So this is a disaster
But
waiting
it's
to happen.
weird. It says to be drawn from the purchase price and then released by the title company.
I know
I mean, if we're sitting here racking our brains on this,
right. So
then-
this is impossible. This is what it should be. Is if the buyer is going to give them 10,000 to move, we should do a note, a mortgage, have it recorded so that if it falls through and the seller doesn't pay back the buyer, they can foreclose.
well, we couldn't even do a note and mortgage because the seller is giving the property to the buyer.
Well, what we do is the seller would give the buyer a note and mortgage. So the buyer would have a $10,000 lien.
Which would be released at closing.
Right, and then it'll get released at closing. That would have been the way. Now, even if they're like, well, we don't want to go through the expense. Well, it's not that expense with doc stamps and tangible tax and recordings. Maybe we could have done an escrow agreement and held it in escrow and not recorded it, and only record it in the event that the contract fell through. But this is just riddled with, this is practicing law without a license, and this is getting everyone into trouble.
And I've seen people do it other different ways where they make the escrow amount 0 and then, write it in and do all these other.
Yeah, there's ways to get it done. Okay, the next one. Seller agrees to repair, remedy, replace the following items prior to closing. Additionally, seller agrees to give a cashier's check or money order in the amount of $11.50 to the buyer at closing. And then it says all interior, and it's got a bunch of numbers, plumbing. And then it says, although water heater is working condition, will be able to consider $8.50 for future replacement. I don't know what that means. Okay, so I presume they're referring to a inspection report. So again, something like this, the repairs that need to be done, use the repair addendum. Now, this business of $11.50 of a cashier's check, no. Everything's got to be on the closing statement. So they should have either made it that the seller will pay $11.50 towards their closing costs, or given a credit. This cashier's check at closing is not permissible.
Especially if it's financed. And then the other thing I like about this addendum is no one can ever tell me when they look at it how much the seller is actually supposed to contribute to the buyer. No one can give me a number.
Well, it says the $11.50, and it says it's going to repair, remedy, replace the following items.
But then plumbing.
Yeah, I know, but it doesn't make any sense. Are they supposed to replace the water heater or give them an $8.50? It's totally confusing. Total, well, screaming match at closing. Okay, the next one. This is a VA approved loan. Full price offer is contingent upon property appraising at the asking price. Otherwise, price will be at appraised value of home. Well, that again, that's first of all, this is a VA approved loan. Well, it's not a VA approved loan because they can't be approved until you enter into the contract. So maybe they're pre-approved, and again, pre-approvals we know are pretty worthless. But then it says this is good for the buyer, but not for the seller, because again, as Christian was saying before, there's no floor. So $200,000 contract comes in at 185. Otherwise, price will be appraised of home, then a 185. Big disappointed buyers and sellers that can cause you a lot of problems. So one of the things here is where the addendums are. So since we've got time, I'm going to leave this up here. Is this the last one on here? Yeah. So what I want to go over with everyone is let's kind of give everyone a kind of brief overview of how to handle the appraisals, what your options are. So the first one would be is just to have no appraisal. So that can be done pretty simple as we've got some sample language in there, is saying that the appraisal contingency is waived. There shall be no, this contract is not contingent upon the property appraising. So there's that. Then you've got the other option of they'll pay X amount of dollars over the appraisal. And again, so let's say they may say we agree to pay $25,000 over appraisal. Now, what happened the other day on one of those? It was 25. Oh, I know what it was. It was $25,000 over appraisal. No, you might have seen this on message boards. And then the buyer wanted to bring cash, and there's a loan involved, and you can't do it. It's got to be disclosed. It's got to be up there. Obviously, if these people have cash, it's unreported. There's all kinds of issues and problems. And that's the buyer's problem. They need to figure out a way to either deposit their money, pay the taxes, or whatever the ramifications are, and have everything disclosed and everything up front. I saw some people say, oh, well, just have the seller give the buyer a $20,000 second mortgage at closing, and then they can hand them the cash and pay it. That's fraud. You can't do that. First of all, the first lender, first position may have may not allow secondary financing, and you're not going to go through that. It's the buyer's problem. They need to rectify it. They decided not to allegedly or supposedly report the cash, but they need to deal with it. The other thing is that I hear is these people who say they're going to pay cash over. Some agents are putting in there that they have to show proof of the cash prior to the closing, proof of the funds. So that's probably a good idea to do. What else do we have in those?
So
addendums?
we've got 3 separate things that you guys can use to kind of facilitate this. The first is your rush appraisal addendum, which says that we're still having an appraisal, but we're going to order it on a rushed immediate basis. And it sets forth some timelines and some ramifications of failure to meet those timelines with which to obtain that appraisal. The other one is, like as Barry said, is doing away with the appraisal in its entirety. Now, I've seen a lot of no appraisal contingency addendums thrown around, prepared by some brokerages and some other lawyers that don't address all 3 of them. Remember, I keep saying throughout this course, 3 appraisal contingencies, 2 of which are contained in the financing paragraph of the FAR bar, 1 of which is the appraisal contingency addendum. If you're not going to have any appraisal at all, you want to remove the appraisal from all 3 of those, and our addendum does that. That means even if you can't get a loan because it appraised low, we're removing that as well. So that's option 2. And option 3 is the escalation and de-escalation of the purchase price based upon the value of the appraisal. And all those addendums are contained upon the link in front of you.
Okay, do we have questions?
We have a couple.
Okay, can you, while we're answering the questions, have him print out that solar addendum? Because I told someone I'd address that.
I think it's on our website.
Well, it is, but I want to just go through it with the person on there.
Sure.
Those things. Okay, can you do a lease purchase option on vacant land? Yes, yes, and we have done them. With a backup contract, do the buyer and seller sign, initial and deliver, but include the rider for the effective date? Yes, yes, everyone does sign, because that way it shows everyone's agreed to the terms. Can you add wording in the addendum informing the contract will be terminated if not signed by the end of the day? Yes, and as a matter of fact, that's already in the pre-printed contract. I think it's paragraph 3 or 4. There's something in there about counter offers, but there's also right above where the signature is, there's a place to check on there and add a date in there right before the signatures. So yes, it's already in there, and you can put that in there. So it's right above the signature, exactly what you're talking about. Where do you suggest putting the verbiage that the buyer is willing to pay over the appraisal value, since we use escalation addendum often to be competitive? So use one of those addendums we have on our site and use one of those. What is the best verbiage to use when you represent a buyer on a property that's being sold fully furnished? Most lenders don't want the borrower to include furnishings as part of the loan. Right, because they can't finance personal property. So there's 2 things to do on that. One would be the question is about personal property. So first of all, you should do an inventory. If you're listing and you know it's going to be furnished, right up front, do the inventory, because we like to attach it. So on the first page of the far bar personal property, say, see attached. Now, what the lenders would like to do is, since they can't finance it, is either put there's little or there's no value to the property. So obviously, if it's like a dining room set, you can kind of say that, because what's a used dining room set? But if it's a whole home, then check with your lender to see what their underwriting provisions are. But what you might want to do is put, okay, if it's a whole house, $5,000. So that won't be counted towards the loan amount. In essence, they'll deduct $5,000 from the purchase price and underwrite the loan based on that. But you do need to do that, and you need to make sure you get a bill of sale. And you guys have heard me talk about this before. There's not one but twice in the contract it states that the seller shall provide a bill of sale. One of the national title companies said they refused to do it. I don't know why. And then the agent said, fine, I'll draft one. No, you can't do that. So they need to have that. They should have their legal department of the title companies that have a pre-approved form for a bill of sale where they just insert the items and that's it. Because one of the biggest things is the contract says the bill of sale should have warranty of title. What does that mean? It says the seller is warranting that they own the personal property, just like they warranty in the deed, they own the property, they're warranting they own it. Now, why is that important? Let's say there's some appliances involved that they were financed and through Best Buy or Sears or whatever, and it wasn't paid for. And a week after closing, someone knocks on the door and says, we're here to pick up the $2,000 refrigerator that wasn't paid for. You can go back against the seller because he warranted the title. So as I've seen some agents who draft them and they don't have warranty of title, and they're pretty much worthless. Okay, if buyer agrees to pay X amount appraised value, does the seller have the right to back out of the appraisal if the appraisal came low, or ask the buyer to pay more over? Yeah.
It depends on what's written in whatever addendum you're using. If it just is the language mirrors some of the addendums that you saw a little earlier that just says buyer agrees to pay $750 over the appraised value, then no, the seller doesn't have the right to back out or renegotiate that. Our addendum does give them that ability, though, if the appraised value ends up being less than the purchase price.
Right, and you can, like Tricia said, put floors and caps on it. Okay, can you elaborate on the furniture deduction with your 5,000 example? How would this work? Let's say the contract is 400,000. Are we stating the value ahead of time? Yes. Well, first of all, check with the lender, see what they'll allow. They may say you have a threshold. If it's 5,000 or less, and you put that, then it won't be a problem. If they say, let's say they said no, the 5,000. So you would do your contract at 400,000. The lender then, when they underwrite the loan, will underwrite it as a purchase price of 395 because they'll take out the furniture, and that way they'll make sure it meets the value for appraisal, and they'll only use the 395 value. So this happens a lot with vacation homes. So the lenders know how to take into account that with vacation homes. Okay, the solar panel addendum. So we have that on there. So we first go through and say what the solar system is involved. Then the second thing is financial status of the solar system. So we want them to check the box. Is it owned by the seller, free and clear? Great. So that says it'll be included as part of the bill of sale at the closing. Or is it subject to a lease agreement? And then we have them put on who that is. If it's financed, how much is financed? How much is the monthly amount? If it's leased, when does the lease expire? And then it also says that the seller authorizes the lessor or the lien holder to disclose to the buyer any documentation or information pertaining to the lease or the loan. Then we've got to say on there, if it's to a lease, that whether the seller is going to pay off the system or the buyer is going to assume it. We also put in there if there's an agreement with a third party to sell the excess, because some homeowners have in their systems, they sell the excess power back to the power company or a third party. This needs to be disclosed, and it has information in there for that. So it also says that the buyer will have 7 days to apply for the assumption of the lease or the loan. So it goes through all of those terms. So it's short, it's sweet, that's in there, it goes through. So again, if you have a listing that has a solar, print this out, take it with your listing appointment, have your client give you all of that information, then you can preload this up into the realtor remarks, and then just have them submit this and say that all offers must include this addendum, and then we don't have a problem last minute at the end. Okay. Any other questions up there? Okay. All right, we are going to the slide after that.
Next month's class?
Yeah. Oh. Okay, oh, for your CE credits, don't forget if you have CE credits, go to that link. That way you can make sure you're all signed up so that we can get your CE credits. Also our RETS program, that if you do 11 of our classes a year, you get a pin and a logo, and then you can be a real estate title specialist designation. Do we have another question?
We do, yes.
Oh. Okay, I have a situation where a buyer is buying a manufactured home that is a co-op. Only one law firm is allowed to do the closings in this community, and they have their own contract with the correct specific language. The listing agent did not provide this contract, even though they knew about it, because he knew it would take longer to execute. Buyer and seller executed a FAR/BAR contract. Is there more into that? Yeah. So yeah, I mean, you're kind of, your hands are tied. So now you got to go and get that approved contract that's in there. Co-ops are very different. I will tell you that there is a co-op, I think over in Titusville, that kind of by default, the management over there calls us for every single transaction now, because they're like, you're the only ones that we've run across in the last 5 years that know how to do this and get them done.
So I don't think in that instance that the FAR/BAR is really going to fly. When you have a co-op, you're not buying real estate, you're buying a share of a business. And a lot of people can't, contemplate that because they're obviously going to live there, but you're again buying a share of a business. The FAR/BAR contract really doesn't address that.
Yeah, so contact that law firm, get the contract from them, because one of the questions is going to be, is you buying into the co-op for the land only, or is the mobile home with it? The mobile home is probably not with it, and then you got to handle that separately in the transfer of title for that. Okay. Next month is, deconstruction, new construction. So we're going to go through and talk about national home builder and custom home builder contracts, the do's, the don'ts, things to be aware of, things that you need to be aware of, especially with the national builders. As you know, they're trying to cut you guys out. They try to cut us out. We've had buyers who want to make the selection under RESPA to have us close it. We have one national builder that refuses to do it. There's lots of interests on there. Attorney's fee provisions, custom home builders, we've seen a lot of that lately, where people will either have their own lot, bring in the builder, or it's where the builder brings the lot and then builds on it. So you got to make sure that you have an attorney review these contracts. I just had one where shame on the realtors. It was a vacant lot. The builder built the house, and they used a FAR/BAR as-is contract. It's lots of problems. Do not use a FAR/BAR contract for a new construction home. It doesn't work. There's problems, and you're going to open yourself up to liability. So,
Dave, there are some more above that. Got some more questions real quick.
No, the solar addendum is not an addendum to this, absolutely is not an addendum to the seller's disclosure. It is an addendum to the FAR/BAR contract. The seller's disclosure doesn't have term, no. About buyer paying over the price. When the seller found out it was low, he said he wanted 5,000 more or he's backing out. I feel I could have done something different so my buyer paid 5,000 more.
Well, if you've already closed, there's probably not much we can do about that now. But again, whether or not, and just to read the question for everybody that didn't hear it, back to the question about buyer paying over the appraised value. When the seller found out it was low, the seller said he wanted $5,000 more. He's walking. I feel I could have done something different, so my buyer paid the $5,000. If your buyer's already closed, there's not much I can do or we can do to really kind of rescind or back out that additional $5,000 that maybe should or should not have been paid. But again, it all depends upon the terms of the contract language that you used.
Yeah, we have to see the language of exactly what it was. If it was one of those ones that said the buyer shall pay, no more than the appraised value, then no, he didn't need to pay the 5,000 more.
Mm-hmm.
All right, I'm representing the buyer in the sale of a vacation home. Should I ask the title company to warrant the furniture? No, the title company cannot warrant the furniture. The seller needs to warrant it. You need to ask the title company to make sure they prepare a bill of sale with warranty of title to the personal property for the furniture and the appliances that to be presented to the buyer, the seller to sign and presented to the buyer at the time of closing. I have a situation where I had to send an addendum for name change. Will that name change be counted as contract time? No, because if you've already, that's not, no, if you're doing that, say, 2 weeks afterwards, you decided to change the name, that does not start the effective date over again. Can a seller truly back out at any time and only repercussion for the buyer would be suing for performance? Well, there could be damages and specific performance.
Yeah, so if we all look at the terms of the FAR/BAR contract, the seller's got a remedy and the buyer's got a remedy. The buyer's remedy is to sue for specific performance and other actions at law or equity. What a lot of people don't think about, and what a lot of attorneys that we've defended specific performance cases against fail to see, is that you can also get damages in a lawsuit for specific performance. You can get, rental costs that are associated with not being able to live in the home, things of that nature.
So say the seller refuses to close and the buyer's furniture is all in storage. That could be damages.
Right.
The difference between what they would have paid for their mortgage and they had to forcibly pay in rent could possibly, attorney's fees. If they lost their rate lock, that cost them more. There's all kinds of things that could be taken into account.
Okay, back to the appraisal contingency addendum. If inspection contingency has been lifted and the loan has been approved, but the date on the appraisal is about to expire without a scheduled appraisal confirmed, can the seller dispute the escrow money if the house does not appraise to purchase price and buyer and seller do not come to an agreement on purchase price? I'm going to say call me on that because I'm not sure I understand.
I think what they might be saying, let's say they used the appraisal addendum F and it had August 10th. Mm-hmm. And they got their loan approval, but obviously contingent still upon the appraisal, but the date the appraisal is about to expire without a schedule. So let's say it says in there August 10th, 14th, but they can't schedule it till the 15th. So if they can't schedule the appraisal to the 15th, then the buyer would not have complied with Schedule F, and then the appraisal would be waived in that case, because the F specifically says so. So if you know you're not going to be able to meet that date, you better contact the listing agent and do an addendum to change the date on addendum F to a few days or whatever you need, so that you can do the appraisal and get the appraisal back. So I think that's it, but call us if there's something more specific on that. Okay, let's go back to our screen up there. Okay, so we're going to talk about that. That'll be September.
There's one before that.
Yeah. Okay, so the other thing too is if you guys do business with us, thank you. People don't say that enough today. We thank you. We appreciate your business. These times have been very trying. Please be safe out there. These numbers are crazy. Wear a mask. especially when you're showing property. You never know. Be careful out there. You know, the whole industry is stretched right now, from lenders to appraisers to inspectors, everyone. Be patient with all of your vendors. We have a lot of lenders that are just like, we can't get it done. They try blaming us. That's not true. We can always get it done. The stuff is always ready. But you know, everyone's got to have a little sympathy these days. If your buyer or the parties need 1 or 2 days more, try to have a sense of cooperation. You know, realtors need to uplift the industry and cooperate with each other. Your cooperating brokers try to do that. The other thing too is, if you do business with us, we'd love if you can put a review on Facebook, Google, or Yelp. We really appreciate those. They do go a long way. Follow us on Facebook and LinkedIn. That way, when we have updates, new addendums, things like that coming up, we put them out on there so you can keep up on what's going on. Friend us on there, of course, be part of the closing agent family. If you don't use us now, we'd love to do business with you. Just contact us. We'd like to hear about what your needs are. We set up brokerages, we set up businesses, we do probate, wills, trusts, anything business in real estate related. If you've got a deal out there at another title company and they're having problems closing it, need another opinion on it, let us know. We get 3 or 4 of those every month that other title companies can't close, and a lot of times we'll find a way to get it done. Still has to be legal, but we're finding to get creative and try to get the problem resolved. Anything else to
That'll do
add?
it.
Thanks for joining me today. Thank you all out there. So have a great couple of weeks. I can't believe this year has flown by. Have a good Labor Day out there. Travel safe if you're traveling, and we hope to see you soon at your next closing.